Welcome back to our complete guide to selling your probate property in Tennessee fast 2025. This is part 2 of our 5-part probate real estate series. I'm Molly, your local Chattanooga homebuyer, here to share personal knowledge about everything probate related in Tennessee. And if you caught our first episode on selling inherited property in Tennessee, then you know that we dive deep into the realities of probate sales, estate administration, and the challenges of navigating Tennessee probate courts. And I have personally walked through probate proceedings here in Hamilton County and Knox County, where we've had to sit in those uncomfortable courthouse chairs, and we've had to deal with clerks having bad days as well. But over time, we've learned exactly the right strings to pull to get things moving in the direction that we want. So what I'm about to share with you today in this video are insider secrets that most probate attorneys will charge you $300 plus an hour to tell you, if they tell you this at all. So some of this information, honestly, they prefer you not to know, because if you did know, it would make their job easier and completely dependent on them. We love our probate attorneys that we work with, but this information is just so you can have a little bit of self-education since you just inherited a property here in Tennessee, or you're going through the probate process in Tennessee. So here's a quick reality check. The average Tennessee probate case takes about 8 to 12 months, but with the right guidance and with a clear plan right up front, we've actually helped clients wrap things up in as little as 4 to 6 months just by knowing how the system really works. And on the other hand, I have definitely seen and worked with families who've had to wait over 2 years simply because of a few critical mistakes made early on. Most especially in the beginning of our career, I used to just follow up with people when we didn't really understand the probate process, and it would take them almost 2 years to get ready to sell. But now we like to guide our clients up front so they can get the best result out of the probate process. And the difference wasn't really having some fancy system or even just selling to a cash home buyer. It was actually just simply understanding how the Tennessee probate court really works and following the proven steps to avoid the common pitfalls that most homeowners will get into that will actually slow down your inherited property sale. So when you know what to expect and how to move things forward up front, and you have that information, then you can save yourself a lot of time, confusion, and of course, stress, because there's a lot of stress when it comes to handling all the moving parts of selling a probate property in Tennessee. So here are some things that the Tennessee probate court system doesn't want you to know. First, let's destroy some myths, right? So Tennessee probate isn't some mysterious black box. It's a systematic process, but the system does have some unwritten or lesser known rules and little known details that can make a huge difference in how quickly your case moves through the actual probate system. So let's go into the 2 types of Tennessee probate that matter the most for inherited property. Let's talk about the most court involved way to sell an estate here in Tennessee, which is the formal probate, also called supervised administration. And in this process, the probate keeps a really close eye on every major step that you're doing. So that means from the moment that you file probate and you file the will and the petition, to paying off all of those debts, to selling or transferring that inherited property to the rightful heirs, the court has to sign off on just about everything when it comes to supervised administration. So when does the supervised probate come into play? Well, you'll usually end up here if there are family disagreements, questions about whether or not the will was valid, or the person was in the right mind when the will was signed. Maybe there are complicated debts, or if the estate is especially large or tricky to manage, this will most likely lead you to supervised administration. The court can also require it if someone challenges who should be in charge. So if you and your siblings are arguing on who should be in charge, or there's no clear executor, then the court most likely will opt in for supervised administration, just because there's a lot going on with that estate. So what does the probate process actually look like? Well, you will start by filing a petition, the will if there is one, and the death certificate with the probate court directly. And at this time, the court is going to appoint a personal representative, someone often who is called the executor, or in other words, the administrator, who needs to take an oath in that court, and they may need to post a bond. And that representative has all the inventory of the assets of the deceased. They're going to be responsible for notifying the creditors and beneficiaries, and they will be responsible for getting court approval for paying off the debts and handing out the inheritances at the end of the sale. So any big move like selling a family home needs a green light from the judge, but the whole process is a public record, and it can take anywhere from 8 to 18 months, sometimes longer if there are disputes or complicated assets, which I have seen far too many times, and it is far too common. So why does probate in Tennessee take so long? So supervised probate means more paperwork, more court hearings, and more chances for delays, especially if someone contests the will or files a claim against the estate. And this process is designed to protect everyone that's involved, any heirs, beneficiaries, any creditors. This process makes sure that everything is handled by the book and according to Tennessee law. So of course that is going to take a lot more time. But the bottom line is, if your inherited property situation has any complexity to it at all, there are any disagreements, or the judge sees that there are a lot of moving parts to this, then the court will likely require supervised administration. And yes, this is going to be the most time-consuming probate route, and it's going to be the most costly, but it does give everyone the peace of mind that the estate is being handled fairly, legally, every single step of the way, and everyone is getting their fair portion. So the second type of probate is the summary probate, or what we call unsupervised administration, or even small estate affidavit. So think of unsupervised administration as the hands-off version of Tennessee probate. This is the one that everyone hopes to be able to go through. After the court officially appoints a personal representative, usually the executor named in the will, again, if there is one, the court will step back and let that person handle almost everything. So paying off those debts, like we mentioned before, selling the house, working with an agent or a cash buyer, distributing those assets to the appropriate beneficiaries and heirs, handling the debts, handling any creditor claims. And they don't really have to ask the judge for permission for every single move that they make, whereas you do in supervised administration. So this is definitely going to be a big contrast to that supervised administration, where you're going to be stuck waiting for that court approval at every turn. But it doesn't, and it can make it slightly less expensive as well, because you can move a little bit quicker and kind of move at your pace. So who qualifies for this full administration or unsupervised administration? Well, estates under $50,000 in value, and this doesn't only contain to personal property. It's not only real estate. Anything under $50,000, they may use small estate affidavit process. Or when you have a larger estate or real estate is involved in Tennessee and there are no disputes among the heirs and the will is 100% clear, you can often request what's called unsupervised administration instead of the standard fully supervised process. So this is something that most people don't know they can actually request. So how do you try to qualify for that unsupervised administration? Well, most families can qualify for this faster track if, number one, the will specifically doesn't require court supervision, or there are no fights, no disputes amongst the heirs. Maybe there's only one beneficiary, or maybe there's only one heir, one living heir. The debts and the assets are pretty straightforward, so there's no tangled up business interests or unusual property agreements that they may have made during the time that they were living. You know, if the court agrees that there is no need for extra oversight, you could potentially qualify for that unsupervised administration. And it's a good idea to ask your attorney directly if you qualify for summary or unsupervised probates. You know, have the will, have the asset list and the death certificate pulled up and ready to go, so you can speed up your petition when you go ahead and process that with the court. Many families don't realize that this is an option, and they miss out on a much faster, less expensive process just because they think that they have to go through summary probate. And I always tell my clients, if there are no disputes, if there are no complex debts, and the will again is clear, then you should push hard for that unsupervised administration when you reach out to the courts. It can cut that Tennessee probate real estate timeline in half. So how does Tennessee probate work in different counties? Well, not all Tennessee probate courts are created equal, and here's what I've learned about working in different counties. Let's start with Davidson County in Nashville. Have you ever tried to get something done at the DMV on a Monday? Well, that is exactly what Mondays and Fridays can feel like at Davidson County's probate court. They're efficient, but they are always swamped. So here's my insider move. File your paperwork early in the week, like Tuesday, Wednesday, or Thursday, early morning, and you could potentially get more attention when the docket's a little bit lighter. And if your case is simple and uncontested, ask about their expedited docket. It can move things along way faster. Now moving on to Hamilton County in Chattanooga. Hamilton County's probate court is its own well-oiled machine. I have handled the most cases here in Hamilton County, and they love it when you show up with every single detail in place. So please do not scamp on your paperwork. You shouldn't scamp on your paperwork at any point. But when it comes to Hamilton County, if you have your stuff ready to go, they will take your case a little bit more seriously. Here, the clerks are honestly some of the friendliest clerks that we've met through all of the counties that we've worked with, and they will walk you through the process if you're kind and patient with them, and they may even share a couple of their own insider tips for you to keep things moving. So express kindness when you're working with them. And then Knox County, which is in Knoxville, you know, this county runs through Chancery Court. So they've been known for being very thorough and sometimes to a fault, but you know, they are fair. And here's a pro tip. When you go in there, ask the clerk's office if they can hand you a probate checklist. This probate checklist will lay out every single step that they need in order to process this probate. It's really like having a roadmap for the whole process. And it's actually saved more than a few of my clients from missing important information or missing an important step in the probate process. Moving on to Shelby County in Memphis. Shelby County's probate court court is its own division, and they've seen it all. They've seen complex estates, big families, you name it. I mean, there are generations of families in Memphis. And so the timelines can stretch out. Patience is going to be your best friend here, most especially with the clerks. But don't worry, they do know how to help you sell your inherited property inside and out, and they will get you to the finish line if you just express a little bit of patience. Let's talk about the critical first 60 days of probate in Tennessee, because this is where most families either set themselves up for a smooth process or end up losing months and thousands of dollars in delays. So week number 1 through 2 is filing probate the right way. Most people think that you just file the petition and you're good to go. But in Tennessee, you want to come in strong. You don't want to just do the bare minimum. You know, if you can, file a comprehensive packet. That means that you have your petition for probate. And if you want things to move faster, make it specifically request unsupervised administration. You have the original death deed or the death certificate. You have the original will, a list of all the heirs, their addresses, their contact information, any preliminary inventory of assets. Even if this inventory list is not complete yet, if you can provide a full packet to them, they will help process your case faster. And don't forget the publication notice requirements either. So I see so many people file a skeleton petition and then they unfortunately have to go months back and forth with the court for missing documents or additional information. So be smart about this. Make sure that you have everything up front versus going back and back trying to get it done, especially when you're in the middle of trying to sell the property. And week 3 and 4 is the publication trap. So here's what most attorneys are not going to mention to you in the beginning is that Tennessee law requires you to publish a notice to creditors in a local newspaper, but not all newspapers are created equal. So some publish notices only once a week, which can add weeks to your timeline. And it's crazy in my opinion, but that is the way that things work. So my advice is to use one of the major daily papers in your county, like the Tennessean or Chattanooga Times-Free Press. Maybe if you're in Knoxville, try the Knoxville News Sentinel or the Commercial Appeal in Memphis. So these papers publish every single day and their legal departments know the probate drill. Month 2, setting up the creditor claim period. Now you've got a mandatory 4-month window for creditors to step forward. So just be aware you've got that 4-month period. But how do you handle this period is going to make or break your timeline. So here is some advice that I give my clients, and you could take it or not take it, but it really could help you speed up your process, is do not just sit back and wait for the creditors to respond to the publication. You know, try to be proactive and reach out to these creditors right away, especially if you know what debts are owed or what creditors need to be paid off. So that could be utility companies, mortgage companies, hospital bills, credit cards. Try to get those payoff letters immediately, even if you're not going to pay them off right now, but just collect them so you know what needs to be paid off. And then order a comprehensive lien search from the county clerk's office right away. Don't wait for the title company to find surprises later, because you can either wait and once you open up title, then you have to handle these liens and these payoffs. But if you do it ahead of time, at least you're aware of what you're getting yourself into, and you can express that to the end buyer as well if necessary. And here's a step that you should not miss: choosing the right attorney. Now, I have seen people go at this alone. I have certainly bought homes from people that have done this process by themselves. But when you are looking to work with a probate attorney, keep in mind that not all attorneys are created equal, especially when it comes to inherited property. And you should definitely watch out for red flags. So if someone says that they also do probate, but they can't explain the difference between supervised or unsupervised administration, or they just go ahead and quote you a flat fee without asking you about your situation, then I would personally keep looking for a more experienced attorney. You know, you really want someone who's specialized in Tennessee estate administration. You want them to ask good questions. You want them to know about your goals, and you want someone who actually knows the clerks in your county. You want the clerks to know them and like them. And that's how you get realistic timelines and you can avoid nasty surprises down the road. If you're seeking a really high qualified probate attorney here in Tennessee, then please give us a call. We'd be happy to refer you a few professionals that we've actually worked with ourselves in the past. And the bottom line is that the first 60 days are your absolute foundation. Do your best to get organized, be proactive, and don't be afraid to ask for help from someone who knows the Tennessee probate ropes. You know, that's how you're going to protect your money. That's how you're going to protect your peace of mind and hopefully protect your time as well. So let's talk about the Tennessee probate court approval process for selling inherited property, because this is where things get really specific and a lot of people can get tripped up. Remember, if you're selling a house through probate in Tennessee, whether it's full or partial administration, the court is still going to need to sign off on that sale before anything moves forward. So just keep that in mind. You can't just sell it direct yourself, unfortunately, without the court's approval. And if you're selling to a traditional home buyer, so an owner occupant, someone who is going to be getting a mortgage and moving into that property to make it their residence, the court is going to want to see proof that you are getting fair market value for the property. Most especially if you decide to list the property on the market, they want to see that you've had all the efforts of trying to market that property and get the best offer. So that usually means in bringing a CMA, a comparative market analysis, which you can get from a real estate agent, or potentially you might need to get a formal appraisal, which you'd probably have to pay for. It could cost you anywhere from $350 on the lower side up to $1,000, just depending on what type of property you're working with. And the court wants to see that you've actually marketed that property, again, typically at least for 30 to 60 days. So they don't want you to see it on the market for 15 days and come off the market. They want to see that you're not just taking the first offer that comes along and you're really trying to get the most for that property. They love to see multiple offers because that shows them that the property is priced well and that there's actually real interest out there in the market for your home. Now, if you're selling it to a cash buyer or one of those We Buy Houses or an investor who buys inherited homes directly, then the process can certainly be a lot more streamlined. And the court is aware of these types of investors and or buyers out there in the market. You know, they will still want to make sure that the offer is reasonable compared to what other property is worth in the area, but you can often skip that long marketing period, the showings, working with an agent, even on realtor commissions, because there is going to be no financing contingency, that these deals are likely to get approved a lot faster with the court. And they understand that. They understand that they're working with a cash buyer that knows what they're doing and is buying the property as is. And of course, or I don't know if this is obvious, but there is less paperwork and fewer hoops to jump through when you're selling that property as is directly to a cash buyer. So no matter which route you take to sell the house, you need to file a petition with the court, include all the details about the sale, and notify the heirs of any interested parties in your property. The court may potentially hold a hearing to review everything and make sure that it's in the best interest of the estate and the estate's beneficiaries. But once you get that court approval, you're clear to close and you can finally get that property sold. Whether you're selling to a traditional buyer or a cash buyer, you can always ask your local probate court what they expect when it comes to the right documents and requirements for either one of these situations. And here is the court approval timeline hack. So most attorneys file for court approval and then wait for the court to schedule a hearing. But here's what we do, and here's an insider move if it does apply to you. You can request an expedited hearing for specific hardship situations. So hardship situations would be, or hardship reasons for a Tennessee probate court would be property deterioration or vandalism concerns, most especially if it's vacant, significant carrying costs affecting the estate value or the resale value. Maybe there are multiple heirs that are needing distribution, or potentially urgent financial needs of heirs like medical emergencies or bills. And I have actually used this successfully to get hearings scheduled within 2 to 3 weeks instead of 6 to 8 weeks, which is the usual timeline to get that hearing scheduled. This Tennessee probate court approval timeline hack is a little known secret that can hopefully save you weeks, if not at least sometimes months, when selling inherited property here in Tennessee. So when you file your motion for court approval, include a detailed explanation of the hardship and supporting documentation, like photos of property damage, utility bills, code violations, any county fines for the condition of the property, insurance notices, medical bills, or statements from the heirs directly. Courts are much more likely to grant your request when you clearly show them how waiting would harm the estate or harm the beneficiaries directly. And here's a pro tip. Work with a Tennessee probate attorney who understands how to leverage and expedite the process and file the right paperwork the right way. Remember, not every lawyer is proactive about this, but it can make a huge difference in your timeline and, of course, your bottom line. Let's discuss the Tennessee probate process with multiple heirs, rules, challenges, and potential solutions for you. So if there are multiple heirs involved, do get ready for a few extra layers of complexity in the probate process, because Tennessee does have strict rules to ensure that every single heir's rights are protected, and that can mean more steps, more paperwork, and unfortunately, sometimes more drama. Notifying all of the heirs is mandatory. It is not just a nice gesture on behalf of Tennessee court. Every single heir does have to be formally notified about the property sale, and the Tennessee court takes this law very seriously. So what does this mean for you? Well, when you're the executor or the personal representative, then you've got to give the court a full list of all the heirs' names, mailing addresses, and how those people are related to that person who passed away. If you have this, you may not know of some heirs. And it doesn't matter if they live across the street or they live across the country, every heir has to be included on this list. So what if you can't find an heir? Well, if the heir's whereabouts are unknown, the court isn't gonna just let you skip them. You're most likely gonna need to publish a notice in the local newspaper still, and in some specific cases, the court may even appoint a guardian ad litem to represent that missing heir's interest. You'll also need to show the court that you made a real effort to track them down, and think about reaching out to family members. Maybe you should check public records, family trees if possible, and even potentially hiring a private investigator or a professional if it comes down to that. If you skip this step or you do it wrong, your whole probate timeline can grind to a halt. The court won't approve any property sale or distribution until every heir has been properly notified and given a chance to respond. And I've seen cases get delayed for months just because someone missed this step or they did not do it by the book, and potentially heirs coming out of the woodworks claiming interest in the property. And if you're dealing with heirs or minors who are legally incapacitated, the court will appoint someone to look out for their interests as well. And if the will was probated in another state, but there's property here in Tennessee, you'll still likely have to know all of the heirs of anything happening in this state. What happens if you discover an heir that you didn't know about, or an heir comes forward during the publication process? When the probate notice is published in the local newspaper online, there's a possibility that an estranged family member or a distant relative or even heirs who had no idea that the person passed away could potentially come forward. And that's actually the whole point of the notice, is to give everyone with a legal claim a fair shot at claiming that interest, right? So if this happens and the probate process has already started, then you are required to formally notify them and include them in all of the proceedings, just like you would any other heir. And this might mean sending, certified mail, updating your paperwork, or even pausing the whole probate process a bit while everyone gets up to speed and all heirs are fully included. Now, I do not want to sugarcoat this. This can certainly delay your probate timeline, sometimes by weeks or even months. I have personally seen it happen, and it's not pretty, but it is going to be absolutely necessary because Tennessee law is designed to protect everyone's rights, even if they were out of touch or out of the loop of the passing of the person's home. The court wants to be sure that every heir has a chance to participate, raise their concerns, or even contest the will if there is a legitimate reason. If you're not sure how to handle it, then this is a great time to reach out to that expert Tennessee probate attorney. He can walk you through this process and the next steps so you can actually keep your case moving forward instead of coming to a stall. And what happens when heirs disagree and you guys cannot come to an agreement on what to do with the property or even the interest? Well, heir disagreements are one of the most common reasons that Tennessee probate cases drag on. If everyone is not on board with selling the property or with how the proceeds should be split up, then the court has a few tools to resolve this conflict. Number one would be mediation. So the Tennessee probate court often requires mediation as a first step. And this will give heirs the chance to work out their differences with the help of a neutral third party, hopefully avoiding a drawn out court battle, which no one wants. Mediation is your first step. And if you can deal with it as amicably as possible, I highly suggest it. Second would be partition proceedings. So if mediation does fail and you can't come to an agreement, then the court can order a partition sale, especially forcing the sale of the property and dividing the proceeds among the heirs as they see fit. So this is usually the last resort, since it can mean selling the property at auction and sometimes for less than market value, because by the time you go to auction, you just have a bunch of sharks at the lowest and shortest end of the feeding pool, and that is not what you want to do. Number three would be buyout arrangements. So in some cases, one or more heirs may want to actually keep that property instead of selling it, and the court can approve a buyout arrangement, allowing those heirs to purchase the shares of the others at that fair market value. So why does this matter? Well, multiple heirs mean more moving parts, more people to notify, more signatures needed, and more chances for disagreement. So if you're an executor or a personal representative, your job is to keep everyone informed and follow the Tennessee rules to the letter, because failing to do so can lead to costly delays, the court intervening, or even potential lawsuits amongst family members. If you're working with a probate attorney who has experience handling estates with multiple heirs and inherited property sales, then they can definitely help you navigate this process. Notify the heirs themselves, mediate disputes on your behalf even, and help you keep this probate process on track altogether. So let's get into how to get the most help from Tennessee probate court clerks. Probate clerks see it all, from simple estates to complicated multi-heir property disputes. While they can't really give you legal advice, they can absolutely help you navigate the probate filing process and make sure your paperwork is in order, and they can point you in the right direction for the right forms and the right checklists that are specific for your county. Your local probate clerk can be your best friend and one of your best resources if you know how to approach them the right way. So here's how to work with them effectively, and this is based purely off of experience. Call ahead. Every Tennessee probate court has its own preferred filing procedures, but calling ahead before you show up lets you find out exactly what documents you'll need or whether or not you need an appointment. Number two, you should bring complete documentation. So have your petition for probate, the original will if available, death certificate, a list of any heirs, and any preliminary inventory ready to go. Incomplete filings are the number one reason for delay. And number 3, be respectful and patient. These clerks handle a huge volume of cases all the time, and a little patience goes a long way. So treat them well, and they will often go out of their way to help you. I can't tell you how many times just bringing someone a coffee or a box of donuts will make them want to help you actually get through this case. And number 4, ask for their local probate checklist or any local requirements. Most Tennessee counties have their own probate checklists or step-by-step guides that are not going to be posted online. So going in directly and asking for these can save you from missing a critical step. It is going to be called their probate checklist. And here is what not to do. Do not show up unannounced and expect immediate help. They are always overwhelmed and they are not going to get to your case right away. Some probate courts in Tennessee require appointments, and especially in larger counties like Davidson, Hamilton, or Shelby, you're rarely going to get away with just a walk-in. And do not argue about requirements or court timelines. You know, this is the law and the clerks don't make the rules. So unfortunately, they just enforce them just like any other government official. So arguing with them or trying to fight directly with them will slow things down and get them on your bad side. And you shouldn't ask for legal advice. Probate clerks cannot interpret the law or tell you what to do in tricky situations with multiple heirs or contested wills. Don't submit incomplete, sloppy filings. So if you're missing documents, your case will get kicked back. You should count on it, and you'll lose weeks, sometimes months, waiting for another hearing date. Refer to the checklist that I will provide in the description below of all the documents that you need. Getting on the good side of your probate court clerk can make your whole Tennessee probate process smoother, especially if you're trying to sell inherited property quickly, or you are going to have multiple heirs to notify and multiple heirs to deal with during this entire process. They know the ins and outs and local probate rules and can help you avoid those common mistakes that we've been talking about when it comes to probate property sales, as well as estate administration. Tennessee probate doesn't have to be a nightmare. If you know how to work the system, stay prepared, and push the right buttons at the right time, then this knowledge and this strategy can totally work for you and help you protect your family's inheritance. And let me leave you with a real world example, because we had recently just worked with, let's say, the Johnson family here in Chattanooga, and they inherited a home with 3 heirs, and everyone was worried about a drawn out probate process, and they were worried about mounting bills. The home was vacant. 2 of them lived out of state. And instead of going through the motions, we decided to take a proactive approach with them. We filed for independent administration because everyone agreed on one person being the executor. We got all the paperwork in order from day 1, and we negotiated directly with creditors through the entire process to clear up old liens. We even worked with the Hamilton County probate clerk in person and over the phone and via email to fast track the sale, citing property deterioration like code enforcement violations, overgrown grass. I mean, the home was a total teardown. And the result of that was that we were able to wrap up the entire probate process and close the property, and they were able to sell the home, earn their proceeds in just under 6 months, saving the family over $7,000 in carrying costs, and I like to believe mountains of stress. So that is the power of understanding Tennessee probate and using every single tool at your disposal. And if you're facing an inherited property or probate headaches here in Tennessee, and you're looking for a reputable cash buyer in Chattanooga or Knoxville or Cleveland or anywhere in between, then please give us a call. At the very least, we'll walk you through your options and help you avoid common mistakes and make sure that the family gets the best possible outcome for everyone. And don't forget, this is only part 2 of our 5-part series. In part 3, the next video, I'm going to be diving into Tennessee inherited property tax implications and legal pitfalls that can cost you thousands. I'm going to dive deep into tax strategies that is going to save you some serious money and help you avoid legal mistakes that could potentially destroy your inheritance value. So go ahead and hit subscribe, leave any questions or comments below, and I will make sure to get back to you, and I'll see you in the next video.